So let's talk now about the process of redundancies. So as normal redundancies might start with layoffs, we'll discuss layoffs first of all. So layoff, as set out in the Redundancy Payments Act, has three elements. The cessation of employment because the employer is unable to provide work where the employees were recruited to do, and the employer reasonably believes that the cessation will not be permanent, and the employer gives notice to that effect to the employee prior to laying them off. It's important, even though we're dealing in a pandemic time, it's important that we still follow the guidelines as laid down in the legislation, otherwise we'll be at risk of dealing with issues down the road. One of the key elements of a layoff is providing notice, and one of the first questions employee ask in layoff scenarios is, can an employer lay you off without notice? As an employer, the law states you must provide notice to your employer before laying people off. So while you can make layoffs without providing notice, it is a breach of the redundancy payments legislation and will expose your business to various claims from disgruntled staff. Employers must give as much notice as is reasonably practical, which in the current crisis may be very little notice in reality. Notice does not have to be in writing, but it would be a matter of best practice to provide confirmation of the layoff period to the employee in writing. The easiest way to comply with the requirement is to provide notice, is to issue the employer with the temporary layoff form, which is known as the RP9 form. Failing completing an RP9 form, I would issue a letter just explaining the situation so that they can take that along to the Social Welfare Department. When you're laying people off, be mindful of what the contract of employment says. So go back and have a look at your contract of employment. If you fail to include this vital provision in the contract of laying people off, you risk suffering a layoff compensation claim for unpaid wages. Failure to pay wages without consent can leave an employer open to a WRC claim for back pay under the Payment of Wages Act. In practice, the majority of employees accept layoff without pay in preference to immediate redundancy, in the hope that work requirement will build up again and the employment can continue. When you are selecting employees for layoff, an employer should apply the same selection as used for redundancy. So based on the layoff information I've just given, you can see that it is part of the redundancy process. So there are 5 grounds for redundancy. And the 5 grounds are: employer has ceased or intends to cease to carry out the business for the purpose for which the employee was employed, or in the place where the employee was employed. Requirements of the business of the employee to carry out work in a particular kind has ceased or diminished. The employer decides to carry on the business with fewer or no employees by requiring another employee to do the work of the redundant employee. The employer decides to work being done is to be done in a different manner for which the employee is not qualified or trained to do. Or finally, the employer decides that the work being done is to be done by a person who is capable of doing other work for which the employee is not sufficiently qualified or trained to do. They're the 5 grounds for redundancy. In addition, the employer must show that the fair procedures were followed in carrying out any redundancies. There is no redundancy if the employee's contract is renewed, or if the employee is re-engaged under a new contract by the same employer and the new arrangement is to take effect immediately, or if the renewal or re-engagement follows an offer in writing made by the employer before the ending of the current contract and the new contract takes effect immediately or no later than 4 weeks from the end of the previous contract. If the proposed action does not fall into the above grounds, then it is not redundancy. So if you have selected someone that was at risk of redundancy, and we will go into this later, if you've selected someone who's at risk of redundancy and then you are able to hire them or found a suitable role, alternative role for them, and they accept that role, well then they're no longer being made redundant. So what's genuine redundancy and compensation? If an employer makes an employee redundant and this is not a genuine redundancy, or it lacks impersonality, then this is viewed as very shoddy practice. In essence, the employer will be deemed to be targeting the employee. Remember that it's not the employee that is made redundant, it's the role that's gone, so it's the role that's made redundant. Okay. In addition, in such a scenario, the employee has generally done nothing wrong. Thus, the compensation awards for unfair redundancy are often higher than the unfair redundancy award following a conduct dismissal, as the latter employee did actually commit an act of misconduct and thus contributed to their dismissal. So, a useful approach would be, if you make this employee redundant and the employee were able to take an unfair dismissal claim on the basis then a tribunal will look at three things. Was there a genuine ground for redundancy? If so, was the employee fairly selected for redundancy? And if so, was a fair redundancy procedure followed? So you can see the importance then of following a process. A process could include the following: develop a business case for the redundancy, make an at-risk announcement to all the employees, carry out a first individual consultation, select your staff for redundancy, carry out a second individual consultation, and allow the right for appeal so that fair justice was provided at every step along the way. Again, like in the layoff, before you go down looking at redundancies, check in your contract that there is a clause giving you the right to lay off or make redundancies. If employees are laid off from work, there is no layoff clause in the employment contract, you will need to secure an express agreement of employees to the proposed layoffs or redundancies, unless you can demonstrate that it is custom and practice in your business to implement layoffs. So it's very important that your contracts are renewed and reviewed to ensure that you have got an up-to-date contract that you are following. In determining if a dismissal is an unfair dismissal, regard may be had if the Rights Commissioner, the Tribunal or the Circuit Court, as the case may be, considers it appropriate to do so to the reasonableness or otherwise of the conduct of the employer in relation to the dismissal. The EAT have consistently cited Section 6 as requiring an employer to go through a fair and reasonable redundancy procedure. Remember, fair process is a constitutional right, that's the natural justice. Tribunals have shown a willingness as above to find redundancy dismissals unfair solely on the basis of procedural flaws. So again, I'm just reiterating the big importance of following procedure, documenting the conversations and ensuring that the selection process was a fair process that you followed. Again, when considering making roles redundant, from the outset the employee should be fully aware of the rationale for the proposed redundancy, and they should be formally notified that they are at risk of redundancy. This is just putting them on notice, and it's important to have that at-risk notice given to them. It's important, again, like I said, to have prior consultation with the individuals that are being made redundant. It's also important to handle the employees that are staying and ensure that they are consulted with as well. And I will follow up with some information to them after this. But it is important because this, as I said earlier, it's a very hard time for everyone, from the management right down to each and every employee, whether they are at risk of redundant or whether they are being saved, the roles are being saved at the moment. So again, just to say, look, at all, if you can in any way save making roles redundant by looking at layoffs, looking at short time, looking at reduced hours, looking at change of roles, looking at how can you make the business maybe move in another direction. All of these are worth considering. So we'll just talk a little more about fair selection. Generally, if an employee is claiming that they were unfairly selected for redundancy, one or more of the following is usually at play. Other employees should have been pooled in the selection process. The employer did not follow the agreed procedure. The selection criteria applied was unfair. The employer targeted the employee. Selection was not impersonal. Some employers will put in contracts, last in, first out, but that may not necessarily be the best approach for the employer, because sometimes your last person in might be your stronger employee in carrying out that role. So it's looking at the role and looking at the needs of the organisation in making your selection process, in using your selection process. It's not an opportunity, and again, I have to really stress, this is not a time to target, say you've said Mary's not doing a good job, I'm definitely going to get rid of Mary. If that's where you've targeted someone, and that Mary in the end could take an unfair dismissal against the organisation. So in looking at that pool, before the employer applies the selection method, they need to identify the pool of affected employees. So how many people are carrying out the role? If the role has got the same job title, that more than likely they're carrying out the same role. But maybe there's different job titles as well, that over time the roles have changed, but the roles are very, very similar. So look at the roles and make sure who should be in that selection, that pool of selection. So where several employees are doing the same or similar work, this broadens the scope of comparison. Anyone looking at it will not just look at job titles, they'll go into the actual contents of the job. So know your job description, know what the role is, and look at that take some time to really review the selection pool that you're going to use. So when you have considered your pool, who should be considered within the pool? All employees, fixed-term workers to be treated the same as part-time workers or employees on protected leave, such as maternity, adoptive or parental leave, employees on sick leave. They all need to be considered in that pool. And if someone is out on maternity leave or adoptive leave or parental leave, it's very important that you communicate with them in the very same way as you communicate with your people that are currently in the workplace. So the pool looks at, as I said, anyone on protected leave. It's also, they should be involved in the consultation and selection process, even if this occurs while they are on leave. If the employee on protected leave is selected for redundancy, then the redundancy will only take effect once the protected leave has ended, and provided the employee has not had an opportunity to engage in a consultation process. So if someone's been they're out on mat leave and they're not due back for 6 months, even though they have been selected for redundancy, their role is still secure until they are due to come back to work, and then they can be made redundant. But the employer can discuss the redundancy with the employees that are on maternity leave. So once the employer has established the selection criteria, if there is an agreed selection procedure and the pool of affected employees, the employer must then determine the selection criteria. as I said, most commonly maybe last in, first out, the LIFO method, skills selection matrix, or an interview selection. They're three of the main ways that are selected, the selection criteria might be. We also talk about looking at suitable alternatives. So, is there another role that the individual can do so that you can, again, save the employees from being made redundant, provided they have the skills and knowledge to do that other role. And if there is alternative employment is suitable, then the employee unreasonably refuses to offer, they will not be entitled to the redundancy payment. So if there is an alternative role that they are suited to do, but and they can do the role, that role is no longer redundant for them. So what's the notice period for redundancies? So as you know, to qualify for redundancy, the employee has to be with the organisation for a total of 104 weeks. And then the notice period on top of that, it can be a paid or unpaid notice period. So if they've been with you between 2 and 5 years, they're entitled to 2 weeks notice. If they've been with you between 5 and 10 years, they're entitled to 4 weeks notice. If they've been with you between 10 and 15 years, it's 6 weeks notice. And over 15 years, it's 8 weeks notice. So it's, when you're working out the cost of the redundancy, do factor in the notice periods. So in summary, for redundancies, consider, do you have a genuine redundancy situation? Do you know what the collective redundancy requirements are? That applies for the larger organisations. Have you drawn up a plan of evidence you need to make redundancies? Are you able to explain the reason why you are going to make cuts to your headcount? Have you followed a fair and transparent redundancy process? Have you involved the employees at all stages, tell them what is happening and explain timescales to them? Have you carried out a transparent selection process? And look at the burden of proof.